Co-op boards are type of local. I get in Russia we called it krysha. It was a roof, mafia. But basically, what tends to happen with co-op boards, they have their own kind of intimate rules. They may not be listed in the purchase applications, and you may hear a conversation of a board president or member that's giving you a heads up. Hey, we're not looking for somebody that's coming in here with a let's say, payroll coming in from a nanny position, or we don't want somebody that's coming in here with, a fixed income, or we don't want someone coming in here that's, let's say, in a wheelchair, and this type of information that you will receive, even off the record, you've got to take that opportunity to take it back at them at this point, because again, you cannot be the tip of the sword for that board looking for somebody that they are telling you that they want, meanwhile segregating against everybody else that is essentially discriminatory in nature. We see it all the time, we hear it all the time. The problem that we always have is, how do we prove it, right? One thing that is becoming a lot easier right now is disability. So a lot of times we are seeing that, and disability having to do with pets. Do you have some sort of pet that you are planning to take in with you that the condo or co-op board doesn't allow inside of the building? Well, if the tenant or resident of that unit can show that there is a disability and can provide that this animal is for that disability, then the co-op or the management board at that point, they can't deny that applicant because of the fact that they're bringing in this pet, because now it is an accommodation for a disability, and that's a requirement of the law. We hear that a lot. Another thing that's that we see, and one thing that I've told agents to ask board members of, is when there is a denial, and you have no idea why the denial came in because you see good income, ask the board a question. Ask somebody a question there if you can, because they talk. They're people and they talk, and they may help you or they may hurt themselves. But at the end of the day, you are going to be that individual that is going to provide your client with more information. And at the end of the day, hopefully in the future, you'll be able to fix the situation that hurt your client there. So ask the question in terms of the board and co-op or condo as to why the denial came in. I generally do not like to take a denial at face value. I will always ask and get more information, even though generally they say, we don't have to tell you anything. Unavailable housing. So we see that as well. Sometimes we see properties that are going in and out of the market. Landlords think that they're tricky, and they will use that element as to saying, well, the unit's no longer available to this particular applicant or to any string of applicants moving forward. A month later, you'll see that the unit's back on the market. Don't be inclined to use that as a way to get around your landlord's requirements, because your landlord may push. Just because they take it off the market and you tell that to the applicant, and then later the applicant somehow finds out a month later the unit's back on the property, they're calling somebody like me, they're calling somebody like my office, asking or making accusations and allegations into, hey, I have a family of 4. This landlord was single. I didn't think that they wanted a family, but this proves that they really didn't, because they denied my application, said the unit's unavailable, and a month later I see it's back on. I want something. I think that they violated the laws here. We don't want that call. That's not a call you want to deal with, because then they're also calling the Department of State, and then you're being secret shopped. So again, be that reasonable mind for your clients, and your clients being the landlords. Most importantly, that you need to train properly as to what's allowed, what's not allowed. Don't set different rates for different people. that's going to be a problem. So if you start setting your rental rate with your landlord for $3,000, and then somebody calls in and you set their rental rate at $3,500, that's a question. That's questionable. And again, you don't want to be put in the situation where you're going to be answering as to why you raised the rent for this applicant for $500. Meanwhile, everywhere else you're marketing for another price. That's a biggie. I don't see this much, but sexual harassment. If you have a situation where you have a client that you're having a relationship with, don't do it. Don't represent them on a client, or don't have a relationship with them, whether it's a landlord or a tenant. That's just a big no-no, because at the end of the day, it goes back to coercion. It can always go back to coercion. And as we know, these are big things that we just don't want to answer questions on. And, again, I think that advertising is the biggest issue. Keep your advertisements extremely clean. Do not point to any particular class. Do not point to any particular category of people. Sometimes what I see whether it's an SRO or whether it's a multifamily, somebody saying, well, woman looking for other women to join in a property, or something to that effect. That's just bad news bears. Don't do that. Don't represent somebody that's looking to do the same thing. Mike, you jumped in to say something?
No, I was just showing my face.
Looking good. All right. Disabilities. Disabilities is a big thing, and one of the things that I'm going to continue to mention is the fact that our landlords, our clients, can't make different decisions based on the fact that it'll cost them a few more dollars to accommodate a disability. For instance, if there needs to be a ramp to enter the building, that's something that they're going to have to do. If the mailboxes are too high for somebody to reach that's sitting in a wheelchair, they're going to have to accommodate, perhaps put a lower mailbox to somebody like that. But they can't discriminate, because these are reasonable fixes that the law sees that it's something that can be done. At the end of the day, right now, we're all at risk of having our license revoked or suspended because of the Attorney General's new passing of the regulation. If you have any doubt in terms of what you're being asked to do, how you're being asked to market a particular unit, I think it's always advised to urge on the side of caution, whether it's speak to your team members or your broker or the attorney. Get advice, ask the question. It's a lot easier to be preemptive and proactive than it is to be reactive in the world that we're in. Even though they have these fines capped at $1,000 as to violation, the $1,000 violation does nothing if we are suspended from our license for 6 months, 3 months, or 12 months. That means that we can't get our money, we can't get our commission. Even if things are in the pipeline, that could be an issue. So don't get your bread and butter taken away. Be very conscious of what it is that we're marketing and how we're marketing it. The people in Long Island.
Question, Gennady, about the license revocation. So although you're saying it's $1,000, say that again. So it's $1,000.
Right here. So what they mentioned here is that the violation is $1,000 if they find to be not to exceed $1,000. But because of the new law that was written in by Governor Cuomo, that $1,000 really is of no relevance to us, because the most important thing that we're now concerned about is losing our license. And here it goes. Department of State may revoke the license of a real estate broker or salesman, or suspend the same for such period as it's a department, or in lieu thereof may impose a fine not exceeding $1,000, okay, for a violation of Article 15, which is the fair housing rules. So it can be one or the other, could be a combination. It says here, or in lieu thereof. It's not what we want to deal with, because when you are being addressed by the Department of State, you're getting representation. It's no way costing you $1,000. always protect yourself and ask the proper question of yourself. Is this going to pass the red face test? And the red face test in my world means that if you are standing in front of an administrative judge or on a panel and you're asked as to this line that you wrote, or this text message that was sent, or this statement that was recorded, who was it directed to, and what was your intention behind it? If you can't give a straight answer without turning red as to the legality of it and it's correct, that fails the red face test, and you shouldn't be doing it from the get-go. Get on the phone with one of us, ask the question, let's see if we can guide you in the right direction. And at the end of the day, all it comes down to is just educating the landlord properly as to what they can and cannot do. So let me just open it up to questions in case anyone has any. That's really the gist of the fair housing rules of the don'ts.